more importantly, you can't write punched her in the face.
Closed fist.
Yeah. So you can't.
Why not? I don't even know. You said it like, why can't you say punch in the face?
Because that's a conclusory statement.
Conclusory
A
language
punch
just
is
make it
conclusory.
facially insufficient.
He
You
hit
have
her
to,
with
you
a
have,
closed
you
fist.
have to say
Closed fist.
he struck her. She had, for example, it's not this person struck. It has to be that somebody observed a strike to or the face. Now the hard part is you say to the face, near the face, about the face, right? Because you can't say it's punched in the face because remember, words have meaning. In would be in. It's about punching on the outside of the face. You're closing a fist or you're striking with an open hand. You can't say you either struck with a closed fist, right? Closed fist, because a fist is an actual description of what happens when your hand's closed, about the face. And then you have to reach out and say, all right, how many times? Is it more than once? If it's a couple, that's a couple.
Multiple.
If it's 3 times, that's several. If it's more than 4, that's numerous, right? You have to know that these words are binding to you, and it's a description, right? Why would you put how many times somebody struck somebody in the face? Why? Because you want to establish if you're trying to charge, for example, the assault 2, where it's attempt to cause serious physical injury and causing only physical injury, right? You would be trying to establish how many times they struck them, how many ways they struck them.
There was multiple people, 3 people, 4 people.
It goes to intent, it goes to injury.
If you have a gang assault, you have to be able to say that there's an observation of each person's part in the gang assault, because each person has to take part in order to show that they acted in concert to reach the gang assault charge, right? 3 or more people causing a physical injury by acting in concert. So this is the factual portion, and it's extremely important. And I swear, I am seeing more and more that this portion of these complaints is not written with as much care as it should get.
Yeah, they're not.
And I appreciate your carelessness as a public defender there.
I'm seeing it now as a defense attorney, how I used to write cases as a prosecutor versus the cases I'm getting, and I'm reading, and I'm trying to find the facts where it's at in the complaint. I'm like, is this the facts or is this the law recited in it? Because I can't find it.
Which, by the way, you know where it's the worst? Manhattan.
Really?
Manhattan charges cases like this: assault, reckless assault,
They charge
attempted assault, aggravated harassment under subsection 4, which is just harassment as if it's an assault.
All of them come together, always.
And harassment. So every case is minimum 5 charges.
Yes, assault 3, attempted assault. Yeah.
He's right.
Really?
All
100%.
misdemeanors.
Now think about that.
Yeah.
I'm accusing you of intentionally assaulting somebody.
No, hell no.
Recklessly assaulting somebody, attempting to assault somebody, harassing that person, and if you harass them, I'm also saying you committed a physical injury, which, by the way, is just assault.
Yeah, but I guess...
Yeah.
They sometimes charge 2 harassment.
Which is exactly what happened in Jonathan Major's case. They charged everything under the sun, and they were like, well, okay, reckless assault, we're giving you that one.
Well, the crazy thing is, I did not find Jonathan Major's case that closely, but I don't know, based on what actually happened and what I would imagine was in the complaint, how he just didn't file a facial sufficiency argument.
Oh, he's appealing it. He moved to set aside the verdict. But the reality is, he can't set aside a verdict.
No. I'm saying the defense attorney should have filed a facial sufficiency motion because it doesn't sound like there's actual injury.
They said they didn't know what happened in the
She
vehicle.
was injured. Her finger was bleeding.
And he broke her phone in the car.
I'm telling you, I know a bunch of templates on assault that bleeding a finger is not actual physical injury.
It's physical injury.
It's clearly physical injury.
I like that's physical injury.
That is impairment of a physical condition if I ever heard
I
it.
won plenty of facial
This is the
sufficiency.
discount, baby, okay?
I've plenty of facial sufficiency
And
arguments.
the ADA's writing your cases wrote them wrong. Remember, I told you.
I
These
know
guys
you
are
won
writing
them
them
in
more
front
and
of
more.
probably.
That's what I'm saying. It really makes it easier to write them wrong. Because you write them wrong, it's like nowadays, so pre-2020, because I know we're talking a lot of inside talk, whatever fucking baseball term is. Inside baseball. But a lot before 2020, all you had was facial sufficiency to get rid of a case. Now you have discovery.
Yeah,
but what's more important, when I saw the discovery reform, the thing I was excited about is that there's no partial readiness.
Yeah.
There's no partial
No supplementary readiness.
That shit is crazy. Because you, like, all I want to see in a drunk driving case is a 511. They write up 511 so poorly It's like all you have is or you have a open container or whatever, anything that it becomes a poison pill for the entire case.
What's a 511?
Driving without a suspended license.
Yeah, but they
I
write.
mean, for the audience.
Oh, my
I know
bad.
what it is.
You know the funny is, I know
I know
there's
what it
gonna be
is.
magical words that just describe 511.
Oh, yeah, you should.
509 is what you want.
Oh, it's
for
part of it.
511.
Yeah, yeah.
Oh, you
So
do?
there's little footnotes, and they come out. They look really nice.
We call them citations.
Oh, okay, all right.
But like nowadays, if you write up, so like the whole point I'm bringing this up is because if you put all these charges on this case for no reason, you're just poisoning. Like if you put assault 3 when it's really harassment or really attempted assault, you poison pilled the entire case because I can write a facial sufficiency motion towards the assault 3 and get the whole case dismissed. Which I feel like that's what they should have did in Jonathan Major's case. If they didn't do it, it sounds like they fucked up.
No, trust me. You don't practice in Manhattan, but you have to understand. These judges allow these complaints.
Yes.
Oh, there's no like.
You can't
all
appeal
like
these.
that.
Now you
Yeah,
might look at them and go to yourself. Everything about this complaint is designed to create a redundant verdict, right?
That's
Which, by the way, is what happened in the
culture.
Major's case. He intentionally
borough-
harassed
So,
her,
but if you follow
recklessly assaulted her.
which is crazy.
Every
No, but-
borough has a culture. Like when I pick up cases in Manhattan, it's exactly how he describes it. It's multiple on an assault.
You
A
can look these
simple
judges in the face and
assault.
go, Judge,
But
what
happens when they see a?
It's okay.
What happens when they see a facial sufficiency argument? They just don't take it seriously.
It depends. I mean,
depends on the
it depends
facial
on the
sufficiency argument.
judge
For
and
that,
the
it's
and
not
the
gonna
motion.
work.
Yeah, but
It's the standard.
what usually happens when you have those type of charges is at jury you can beat the top ones, you can beat the ones that you're like, and then the reckless is the one that you go down. There's like for some reason or another, whether it's a jury trying to just make everybody happy or you felt something was wrong
But
and
that's
so
the-
they can
that's the
give a
problem,
conviction.
right?
You'll beat
What doesn't
every
they-
charge but one.
It has
Remember,
to
juries
be-
are not allowed to
it has to
consider the
legally
level of the
make
crime or the
sense.
possible consequences. So you hand the jury intentional assault and reckless assault. They're like, oh, well,
He
it
did
was an
intend,
he
so
didn't
it
mean
wasn't-
to.
yeah.
It was reckless,
Yeah.
fine.
Yeah.
I see the injury. I'm not saying it doesn't exist. I see the photo of the finger scratched up.
And they
What
said-
they're not saying is you're treating him with the same level of criminal culpability as if he intentionally assaulted her when he was defending himself from the brutal attack in the middle of the night.
Facts.
They said they didn't know what happened in the car. So